All right, well, it's 7:30, so we're gonna get started. Um, Thank you all for coming. It's great to see you all. This is part of Beth Meyer's Monday night series we've been doing throughout the pandemic. So if you know anyone that wants to give a presentation talk, they can reach out to me. My name is Julia Snyder. I'm the programs coordinator for Beth Meyer. Tonight, we're going to hear from Justice Mark Davis of the Supreme Court of North Carolina. He is the first Jewish member of the Supreme Court in its 200-year history. And tonight he'll be speaking about the parallels between the Torah and our modern legal system. And at the end, we'll have time for a Q&A after the presentation. So could everybody mute themselves throughout the presentation so we can hear? Thanks. I'll hand it over to you.
Well, thank you so much, Julie, and hello, everybody. Delightful to be with you tonight. I wish it was in person, but unfortunately the science just isn't cooperating on that as of yet. These certainly are strange times, but we will get through them. It is a huge honor to be the first Jewish member in the history of the North Carolina Supreme Court. And people have asked me a lot over the past year and a half whether being Jewish has any direct bearing on the way I do my job. And in the strict sense, no. I mean, I take the same oath that everybody else takes to apply the law fairly and impartially as it is. But I think indirectly it does have an influence. A big part of being a judge is making sure that everyone's rights are respected and the Constitution is enforced and people are treated fairly. And when you're Jewish, I mean, think about it from your own experiences. Excuse me, as a people, I mean, unfortunately, we're no strangers to persecution. We're no strangers to societies where there was no equality under the law, where there were no individual rights that were respected. And so I think being Jewish as a judge and as a lawyer makes you appreciate even more just how precious these rights are, and makes you even that more emphatic about making sure that everyone is in fact treated fairly. So in that respect, I think it does have a relation. And I'll tell you quickly, I had my Sandy Koufax moment, as I call it, shortly after I joined the court. Some of you may remember in 1965, Sandy Koufax was supposed to pitch in the World Series for the Dodgers, and he refused to do it because it was on Yom Kippur. And he said, no, I can't do it. Yom Kippur is more important than baseball. Well, on a smaller scale, I had my own moment like that. I found out that our court schedule, which is plotted out a year in advance, called for us to hold court as part of our 200th anniversary celebration in another county in the western part of the state on Rosh Hashanah. And I said, no, I can't do it. Rosh Hashanah is Rosh Hashanah. We're going to have to find some other arrangement. And everybody understood it. Everybody was respectful, and it worked out great. But if I ever do get to meet Sandy Koufax, I will tell him that he inspired me on that occasion. So this talk tonight, I've always been fascinated by the fact that on the one hand, we live in a society where there is a strict separation of church and state. And yet, there are so many parallels between our modern legal system and biblical times, biblical law as set out in the Torah. So a few years ago, I decided to try to write a talk on this, which I keep expanding, and you're hearing the latest version tonight. So let me give you a disclaimer at the beginning. This is a very large topic. You could take it in a lot of different directions. And if I don't take it on the direction you were hoping I would, I hope you will chime in at the end during the Q&A, which should be more than a Q&A. It should really be a dialogue. Every time I give this speech, every single time, I learn from the audience, and the audience makes me think about these issues in a way I never had before. And I'm absolutely confident tonight will be no exception. So I'm gonna give a few general thoughts and observations. Then I want to go through an exercise with you. And then, like I said, I'd like to turn it over for dialogue between us. So the backdrop of all this is the notion that we don't live in a theocracy today, but in biblical times, the Israelites did, right? Now that word has acquired a lot of toxic baggage over the centuries. And when someone says theocracy right now, as I just did a moment ago, you probably thought about certain countries in the world and certain other religions where there is no respect for human rights and where terrible things are done in the name of religion. Well, I would say that's a perversion of theocracy, but theocracy just means a system of government where religious leaders rule in the name of God. And that's certainly what existed at the time the Torah was given to the Israelites. So let's go back to the book of Yisro in Exodus in the Torah. I like to say this is the first recorded example of good advice by a father-in-law to a son-in-law. So the Torah had been given on Mount Sinai. There were about 3 million Israelites, and Moses spent the overwhelming portion of his time afterwards adjudicating disputes between the Israelites, trying to flesh out God's word into practical rulings in complex cases involving day-to-day life. And one day, his father-in-law, Yisro, came to visit. And he stayed a few weeks. And during those few weeks, he saw Moses early in the morning go to the mountain and not come home till the end of the nighttime, exhausted. And during those 16, 18 hours, all he had done was try to resolve disputes among the Israelites. And Yisro said to his son-in-law, to Moses, he said, Moses, what are you doing? You're killing yourself. You're only human. You know, you can't spend every waking minute resolving these disputes. It's wearing you down. And we're taught that Moses responded essentially in so many words, well, I have to. This is what God has commanded me to do, to solve the disputes for the Israelites. And Yisro said, well, how about this? Why don't you save the most important disputes for yourself and resolve those? But for the most commonplace, ordinary disputes, why don't you have other judges, other wise people resolve those disputes and save the really important ones for you? And Moses prayed on it, and we're told God approved. And that's exactly what he did. Hence my observation a minute ago, the first recorded instance of good advice from an in-law to a child being followed. So that's a good thing for those of us who are fathers-in-law and mothers-in-law. But that same principle I just described explains our hierarchy of courts in our modern age. When you have some exposure to the legal system today, doesn't matter what state you're in, doesn't matter whether it's federal court or state court, your port of entry is the trial court. In North Carolina, it's called Superior Court or District Court. If you get a traffic ticket, or heaven forbid you're accused of a crime, or you bring a lawsuit or somebody sues you, it all starts in the trial court. And the trial court, often with the help of a jury, makes findings of fact, makes some legal rulings, and there's a winner and a loser. And then the loser can appeal to the next level, which in North Carolina is the court I used to serve on, the Court of Appeals. And everyone has a right to appeal to the Court of Appeals and say, the trial judge applied the law incorrectly and I should get a new trial, a new hearing, whatever. And then the Court of Appeals rules, and there's a winner and a loser. And for the most important cases, those can get appealed to the highest court in the jurisdiction, which in North Carolina is the court I serve on now, the Supreme Court of North Carolina. Obviously, in the federal system, it's the United States Supreme Court. Every state has a high court. New York tries to confuse us because they call their highest court the Court of Appeals, and their trial court they call the Supreme Court, but that's New York for you. They always have to be different, but it's the same idea. So what about the way judges are chosen? Well, going back to biblical times, what Moses did was he talked to the elders of the various tribes, and he directed them to choose people from their tribes who were conscientious, intelligent, good character, and willing and able to assume the role of judges. Well, one could make the position that, or take the position, that's kind of like how we do it in states like North Carolina, where we elect judges, where the people of the state choose at the ballot box the people they want to be judges. So again, we're looking back to biblical times for the way we're structuring and choosing our court system. What about the characteristics of judges? Well, the Torah helps us there too. It tells us judges have to be competent. We try to be competent. They tell us we have to be impartial. They tell us we cannot adjudicate cases in which we have a conflict of interest. For example, if your family member or your best friend or your business partner brings a dispute to the court, you have to recuse yourself. You cannot accept gifts from the litigants. Here's an interesting one that always fascinates me, just as a brief digression. The Torah is very clear that judges cannot favor the poor in disputes with the rich. Now, the reason I find that so interesting is, as all of you know, tzedakah is such a huge, huge part of our religion. In fact, I'm looking at the screen at some people who've devoted their lives to tzedakah. But for this one instance, justice is considered so important that we are taught that Hashem commanded that judges not favor the poor over the rich. In a court of law, everyone is treated equally. But my larger point is all of these characteristics that I just mentioned, being competent, being impartial, not having conflicts of interest, not accepting gifts from litigants, not favoring the poor or the rich, all of that exists today in modern judicial codes that every state, including North Carolina, has. And again, they're drawn directly from the Torah. There is a direct link. Now, what about the process of judging? We've talked a little bit about the structure of a court system. We've talked about how judges are selected. We've talked about the characteristics of judges. But what about the way judges go about doing their job? Well, I submit to you that there are strong parallels there as well between the modern court system and the Torah. So when we decide cases, there's a set of facts. We have to decide the applicable legal principles that govern that set of facts, and then we make a ruling. It's like a syllogism: major premise, minor premise, conclusion. The major premise is the legal principle, the minor premise are the facts of this case, and the conclusion is the outcome. I'll give you an easy example. Some of you know the concept of a statute of limitations. It means you have to bring a lawsuit within a certain number of years or it's barred forever. So the statute of limitations for bringing a personal injury action is 3 years in North Carolina. So let's say so that's the major premise, 3-year statute of limitations. Minor premise, let's say the plaintiff in this case waited 4 years to bring the lawsuit. Conclusion, the lawsuit is barred by the statute of limitations. That's an easy, simple case, and not every case is quite that simple. In fact, most of them are not. But the point is, we live as judges, we operate in a system of precedents, Precedents. I have to say, I'm not talking about presidents, I'm talking about precedents. And so what that means is the way we apply the law to a given set of facts today, that means if a similar factual issue comes up a month from now, or a year from now, or 5 years from now, we're going to apply the same legal principle because we want there to be stability in the law. We want people to understand these are the legal rules that govern these specific fact situations. And so you know as citizens that if you engage in this conduct or someone else engages in this conduct, these are the rules that we want to apply. And that whole notion of precedence, one building upon the other, that is completely based on the Talmud and the Mishnah. Obviously, there could be separate classes, and I'm sure there have been separate classes talking in detail about rules in the Talmud and the Mishnah that have carried over into modern law. And I would not even try to give that speech. I'll save it for the experts. But as judges, we have canons of construction that we use when we deal with ambiguities. What kind of ambiguities? Well, we spend a lot of time interpreting laws passed by, in North Carolina, the General Assembly, sometimes laws passed by Congress, statutes. And despite the best efforts of legislatures, they often leave undefined key terms in the statute. And then a case comes up where we have to decide whether the statute applies or not in the case before us. And sometimes it's a little hard to do so because it all hinges on how you define a key word in the law that the legislature, for whatever reason, didn't define. Now, this same issue came up in biblical times when the ancient rabbis were trying to carry out God's word and adjudicate, like Moses had done, disputes between the Israelites. So let me give you a quick example in biblical times. We're all familiar that we're taught, Orthodox Jews believe you should not work on the Shabbos, right? That's a basic provision of Jewish law. Okay, but what does work mean? Shall not work on the Shabbos. Okay, I think that makes sense, but only if I can only follow it if I know what work means. And there's not a glossary in the Torah, right? we don't know exactly what God meant when he said work. So what were the ancient rabbis to do? Well, they were very smart. They looked at the word for work, which I believe was malacha, and they said to themselves, let's see if malacha is found anywhere else in the Torah. And sure enough, it was in the section of the Torah, a separate section, but still a section of the Torah dealing with the building of the tabernacle. The word malacha is used there as well. And there, as some of you know, there's a very vivid description and a very specific description of the types of work that are used to build the tabernacle. So the rabbis went back to the original problem and said, okay, we've got this word malacha. It's not defined here in the Torah, but it is defined over here. So let's borrow that definition, and let's say on Shabbos, you're not allowed to do those same tasks that were used in building the tabernacle. And that is exactly the type of reasoning that judges use today. As I mentioned a minute ago, we frequently are required to interpret statutes with undefined terms. So what's the first thing we do? We look to other statutes to see if that same term is defined elsewhere by the legislature. And unless there's some contextual reason not to, we reach out and borrow that definition and apply it to our case, just like the ancient rabbis borrowed the definition of malacha. Now, this also comes up a lot. I was talking about statutes, but as all of you know, another very important thing judges do is interpret the Constitution, both the federal Constitution and the state Constitution, which every state has, including North Carolina. And statutes, at least they're written specifically, constitutional provisions, it surprises a lot of people how broadly they are written. And in fact, non-lawyers are sometimes amazed to learn how little guidance there is in the Constitution on these huge fundamental doctrines that, you know, are pillars of our society, our life in America. You know, for example, I'll give you a few examples. The Eighth Amendment prohibits cruel and unusual punishment. I mean, that sounds good, right? I've never met anybody who's for cruel punishment or for unusual punishment, but what does it actually mean when you start having to apply it in particular cases? The Constitution, like the Torah, does not contain a glossary where terms like that are defined. So just like it was up to the ancient rabbis to interpret broad biblical terms in the Torah, judges have had and continue to have to construe these really broad constitutional provisions that are profoundly important to our state and our country without a lot of guidance in the document itself as to what it means. So the US Supreme Court, I think the first case they had, this is just an example, when they had to define what cruel and unusual punishment meant was in 1870. And they said, based on the facts of the particular case before them, that drawing and quartering, burning alive, and disemboweling a criminal defendant are all cruel and unusual punishment, which is good news to all of us. No matter how far we stray legally, we don't have to worry about being drawn and quartered, burned alive, or disemboweled. That's a good thing. But what the US Supreme Court did was they tried to find the essence of what the framers who drafted the Eighth Amendment were getting at, and they focused on inhumane. They seized that as the core principle, that the Eighth Amendment was intended to prohibit inhumane punishment. And I'll give you a few more examples of how it evolved over the years. You flash forward to 1977, the US Supreme Court held that the death penalty for rape unaccompanied by murder, obviously still a horrible crime, but the US Supreme Court said it is cruel and unusual to impose the death penalty strictly for rape without associated murder. Then in 2002, the US Supreme Court held that executing the mentally handicapped was cruel and unusual. Then 3 years later, in 2005, the court held that juveniles was constitutionally cruel and unusual. And then finally, in 2012, their last big pronouncement on this issue, they said that imposing a sentence of mandatory life without parole in prison for juveniles was cruel and unusual. So as you can see, we've come a long way since the drawing and quartering, burning alive cases, but the constant link is inhumane. And you know, whether you agree or disagree, some people have strong views to the contrary, but the US Supreme Court has taken the view that our evolving standards of what is inhumane has changed over the years, and punishment that was what might have seemed okay 200 years ago now offends us. When we, people hear about notching off ears and all these horrible things that were an acceptable form of punishment 200 years ago. But the point is, each subsequent ruling builds on the last one and takes into account shifting societal mores. Let's take two more provisions of the Constitution. You've all heard of the Equal Protection Clause, which essentially says no person shall be deprived of the equal protection of the laws. You all heard that, right? This shocks a lot of non-lawyers, but every single legal principle about prohibiting racial discrimination, gender discrimination, discrimination based on sexual orientation, any sort of discrimination based on treating one group of people differently than another, it all comes back to the Equal Protection Clause. And it's just those 9 or 10 words that I just gave you. No person shall be deprived of the equal protection of the laws. That's it. So the US Supreme Court over the last 200 and some years has had to put flesh on the bones. They've had to decide what equal protection means. And it's changed, as we all know. And just to take racial discrimination as one example, in Plessy v. Ferguson in the late 1800s, they said separate but equal water fountains, separate but equal everything, did not violate the Equal Protection Clause. And then some 58 years later, the US Supreme Court reversed itself in Brown v. Board of Education and said, no, we were wrong in the 1890s. Equality is the key principle here, and there's no equality in having separate swimming pools, separate water fountains, and separate classes for students based on their race. One last example, in the First Amendment, you've all heard about the Establishment Clause, which says Congress shall make no law respecting an establishment of religion. That sounds good. We're not a theocracy in America. So I don't think most people would agree with that. But again, what does it mean? The devil's in the details. What does it mean respecting an establishment of religion? Does that just mean Congress cannot pass a law saying, okay, I'm just going to pick one at random. Southern Baptist is the official religion of America. Or is it more nuanced than that? Does it prohibit any local or state government or the federal government from doing anything at all which even slightly appears to endorse religion? Is it one of those two extremes, or is it something in the middle? And as you know, the US Supreme Court has really struggled with that question. The court has consistently held that it's somewhere in the middle, that Congress and states, yes, they can violate the Establishment Clause even without declaring a national religion or a state religion, but it gets a little, the devil gets in the details when you get in the weeds. Most of the cases that come up involve creches or menorahs or nativity scenes, on public property. Is that an endorsement of religion? And the US Supreme Court has really struggled with that. But the core principle that they've sort of extracted from the text of the Establishment Clause is that the government cannot endorse a particular religious view. But of course, they continue to debate, and always will continue to debate, what is and is not endorsing in a particular case. And then let me talk a word about technological advancements. Goodness, we're living in a time where technological advancements have never been as important as they are right now, right? But how do rabbis deal with technological advancements? And how do judges deal with technological advancements? I'll give you a quick example of each. Let's go back to thou shalt not work on the Shabbos. Well, when cars were invented in the, 1930s, 1920s, rabbis started getting a lot of questions. Orthodox rabbis had to figure out, was it okay for people to drive a car on Shabbos? Was it okay for people to ride in a car on Shabbos? Airplanes came along, same question. And so the rabbis had to do some heavy thinking, just like their predecessors had done. And, it's all over my head, but as I understand it, what they essentially came down to was the notion that lighting a spark, and they went back to malacha. What is malacha? And as I understand it, or maybe this is just how rabbis have dumbed it down for me when I ask the question, because I'm sick, but apparently it has a lot to do with the spark that occurs in the ignition when you start a car, that the spark is what triggers the prohibition against malacha. And so even though there were no cars in biblical times, now of course, So for the last, what, 100 some years, cars have been a big part of our lives. And religion had to adapt to the times and come up with new rules to deal with this change in technology. So what about judges? Same thing. The science is always ahead of law. Judges always have to play catch up. So I'll give you one quick example. The Fourth Amendment, all of you are familiar with the Fourth Amendment, right? It prohibits unreasonable searches and seizures. Well, you know, for the first 200 or so years of America, it was pretty straightforward. A search and a seizure was when the government tried to break down your door, you know, get in your house without your permission and search for contraband, search for drugs, search for weapons, etc. And basically the law developed that if they didn't have a warrant, they couldn't do it unless they could show one or two exceptions applied, such as that there was an emergency reason for getting into your house and there wasn't time to get a warrant. So that was sort of the easy case. Everyone understood what a search was for 200 years. But then technology started. And one particular type of technology I'll mention, in a famous case called Kelo versus United States, that was decided about 20 years ago, law enforcement officers started using infrared camera. Well, in this one particular case, they used an infrared camera using thermal imaging technology to identify heat lamps that were allegedly being grown in the defendant's house, Mr. Kelo. And they operated this thermal imaging technology in the street outside his home, and they confirmed that the heat lamp was showing positive, and so they decided he was, in fact, growing marijuana plants. They arrested him, and his smart lawyer said, wait a second, this is a high-tech search, but it's a search nonetheless. And he challenged it, or she challenged it, as being violative of the Fourth Amendment, and the US Supreme Court agreed. In an opinion written by Justice Scalia, the Supreme Court said that this is every bit as much a search as breaking into someone's home, and the officers needed a warrant to do so. They didn't have a warrant, so throw this case out of court. Just one of many examples of the law trying to catch up with technology when interpreting the Constitution. All right, I'd like to shift gears now, and for the next 10 minutes or so, do an exercise involving the 10 Commandments. I have sort of a perverse mind, and things I think are interesting, most rational people don't think are interesting. But it occurred to me a few years ago, you know, the 10 Commandments is such a huge component of Jewish life. And I just started thinking one day, what if a modern legislature tried to enact the 10 Commandments into law today in America? Would they be constitutional? If the General Assembly, think about the 10 Commandments, and we're going to go through them. But just, you know, let's say they said, it is hereby declared that the 10 Commandments are the law of North Carolina, and criminal penalties attached to any violation of any one of these commandments. Would some or all of that law be struck down on First Amendment grounds? Let's find out. All right. It seems to me the first three commandments are of a piece, as it were. First commandment, I am the Lord your God, and thou shalt have no other gods before me. Second commandment, thou shalt not make unto thee any graven image. Third commandment, thou shalt not take the name of the Lord, in vain. So, would those three, let's talk about them together. Would that fly? Would it be constitutional? So this is where I really miss most of all doing this speech in front of a live audience, because I love it when people raise their hands and we can count how many people say yes, how many people say no. It's a little hard to do on Zoom. So just be thinking in your mind, although if you want to raise your hand, that's fine too, even though I obviously can't see everybody. But what do you think? Would it be constitutional or not? Clearly no, right? All three of those first commandments essentially prohibit blasphemy, and that's okay in a theocracy, but it's not okay in our modern society in America. The First Amendment, the Free Exercise Clause, and the Establishment Clause would cause any court in its right mind to immediately strike down those laws as unconstitutional. Okay, that's the easy case. We've disposed of the first three, but again, those are pretty simple. Let's go to a trickier one, the fourth commandment. Thou shalt honor the Sabbath day and make it holy. What do you think? I see a head shaking. See a couple heads shaking no. Oh, I see Leonard shaking his head yes. Well, you would think this would violate the First Amendment as well, right? Leonard, why were you shaking your head? Can you unmute yourself?
We have blue laws, and
there you go.
Alcohol
there you go.
on the Sabbath.
See?
Pretty clear. It's been held up for a long time.
Blue laws. I love giving this speech because it's always smart audiences and smart audience members who answer these questions. Leonard is exactly right. Consider blue laws. You all know what blue laws are. A day of the week, usually a Sabbath, when you're not allowed to do certain things. And of course, as Jews, we're a minority in America, particularly in the South, and the Sabbath at issue is always their Sabbath, not our Sabbath. So we're talking about Sundays, not Saturdays. Now you would think though, why is that constitutional? Or you might question, is that constitutional? A fellow named McGowan, who lived in the great state of Maryland, had the same question in 1961. Maryland had a law that prohibited certain retail establishments from being open on Sundays. And darn it, Mr. McGowan wanted to make money on Sunday. He wanted to open his store. So he brought a lawsuit, and it went all the way to the US Supreme Court. And they said that the Maryland blue law was constitutional. The Supreme Court said laws with a religious origin are not unconstitutional if they also have a secular purpose. And the Supreme Court said that the state of Maryland, in the record, had given affidavits saying, no, this isn't about religion. We just want a day of rest for all of our citizens in Maryland because they work hard all week, and we think they should have one day of rest and not have to think about work. And the Supreme Court said it's not unconstitutional simply because it coincides with an ancient law that happens to do with religion. Now, you may agree with that or you may disagree with that, but that continues to be the law of the land. To my knowledge, no one has ever seriously challenged McGowan, and it still remains on the books. Julia, are you raising your hand or are you just stretching?
Yeah, I have a question. I think Ellen also has one.
Yes, please. Thank you. It makes me so happy when people ask questions. For those of you who do public speaking, particularly about topics that some might consider boring, I always have this fear that my entire audience is asleep. So it makes me blissfully happy when somebody actually asks a question. So thank you.
I was going to say also, like, in relation to the cycle of our work week and like school schedules, we have Saturday and Sunday off, and those are not necessarily the rest days for all religions.
That's true. That's an excellent point. The legislature made what may seem like an arbitrary decision to some to have no school and no traditional work week on those 2 days, which happen to be the two major days of Sabbath, if you will, for the Christian religion and the Jewish religion. So there you go. That's a great point. Who else had a point?
I did.
Yes, sir.
Thank you. I'm not. It's Ellen.
Hey, Ellen.
I'm a ma'am or whatever. But anyway, I would throw in.
Oh, sorry. Excuse me. Sorry. My eyesight is horrible. I have such trouble seeing on Zoom. Forgive me.
That's okay. It's hard to see on Zoom. But I would throw in Friday because there's an awful lot of Muslims in North Carolina and in the United States. And if you're going to talk about the day of rest, that's actually 3 days over the course of the week. That is the Sabbath. And I'm not sure about other religions besides Islam and Christianity and Judaism, that I know those three that are specific, but I don't know about Hinduism. I don't know about Buddhism and Shintoism and all the others. So whose Sabbath? If you're going to pick a Sabbath, whose?
Well, that's a great point. That's a very good point. The last time I gave this talk.
You could probably pick any day of the week, and you're going to start offending people.
Well, that's true. And as we all know, no matter what you do, you're going to offend somebody these days, right?
Exactly.
The last time I gave this talk, somebody asked a great question that no one had ever asked before. What if in the blue law, they mentioned the Sabbath? What if they said something about blah, 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 and the Sabbath day of the Christian religion, which is Sunday, or and the Sabbath day of the Jewish religion, which is Saturday? Would that make it unconstitutional? I think it would. I think then the state would no longer be able to hide, by some secular purpose. I think it would be right there for everyone to see that this law was motivated by religion, and I think the courts would strike it down.
Yeah, I think,
That's probably why no legislature ever does that.
yeah, when the blue laws were first established, Christians were definitely a hard and fast majority, and there were very few of any other religion other than maybe Jews. There were very few Muslims other than, so they could get away with it a lot more easily than they can today, when there is much larger numbers of so many other religions. I think it would be much, much harder to do that, to try and do what you're suggesting, to say, honor the Sabbath.
Yeah, I think if it ever did come back up before the Supreme Court, they might end up reaching the same result, although they might not. But even if they did reach the same result, I think they would take pains to explain it a little more fully than the court did in 1961. I think they would realize that this was a much more controversial issue today, like you're saying it is, than maybe it was 60 years ago. So in North Carolina, the blue law used to be, as many of you know, it used to preclude selling alcohol before noon on Sundays, but a few years ago, the General Assembly changed it to 10 a.m. as long as that is approved by a local government. When I first was putting this talk together, again, because I have a perverse sense of humor, I decided to try to find the most amusing blue law I could find from around the country. And I did this a few years ago, so there may be an even more amusing one now. But at the time, the one I came up with was Virginia, our neighbor to the north. Their blue law outlaws hunting on the Christian Sabbath on Sunday, except for hunting raccoons. So if you take nothing else from this program, if you're a hunter and you're traveling through Virginia and it's a Sunday and you just get the urge to hunt and you've got your gun in the car with you, be careful, make sure you're only aiming it as raccoons. There you go. All right, getting more serious. The fifth commandment, honor thy father and mother. Most of us on this call are parents, right? Don't we wish that the legislature could enact that into law and our kids would have to follow it? Well, in biblical times, well, all right, so what do you think? Could that be constitutional today? Could children go to prison potentially for not obeying their parents? No. In biblical times, honoring parents was considered synonymous, or at least similar to honoring God himself or herself. But we can't legislate that today, unfortunately, for parents. But consider modern laws in effect in every state, including North Carolina, which give legal authority in all respects over their children to the parent until the children reach the age of 18, which reflects the notion that parents are still worthy of respect, or at least legislators believe that parents are worthy of respect and will act in the best interests of their children. Although sadly, I would say I have about 60 to 65 cases a year of situations where parents do the opposite of acting in the best interests of their children. And those are horrible cases. But luckily, happily, most parents do try to take care of their children in the best way possible. All right, the sixth commandment, thou shalt not murder. What do you think? Well, that's pretty darn easy, isn't it? Of course, of course. The prohibition against murder is the most basic law in any civilized society. First and foremost, we protect life. In biblical times, the belief was that humans were created in God's image, and that's why it was such a terrible sin to commit murder. But in today's secular world, the prohibition on murder, against murder, is still the most fundamental proposition in the law of any society. Now, as all of you know, there is a big distinction between thou shalt not murder, which the Bible says, as opposed to thou shalt not kill, which it does not say, because in the Bible, there's a distinction between so-called shedding of innocent blood versus a lawful killing, for lack of a better phrase. And our law today still recognizes that principle. You can kill in a legitimate case of self-defense, and it's perfectly legal. You can kill, under normal circumstances, if you are a soldier in a war. And if you are, you work for the state and you are administering capital punishment in a lawfully prescribed way. You can operate the syringe or pull the switch or whatever it is, and you are not committing murder. You are committing what the law recognizes as a legal killing. All right, the one some people wait for, seventh commandment, thou shalt not commit adultery. I'll pause for 5 seconds while you insert your own joke here. Okay. What do you think? Can adultery be criminalized? Really missed the live audience. I get such great responses to this question. All right, I see hands. Come on. What do you think? I'm so bad with technology. Are y'all able to unmute yourself?
Yeah. Well,
Okay.
North Carolina did have the law against alienation of affection.
You're good. You're getting
Still
ahead
have
of me.
it? Do we still
You
have
are
it?
2 steps ahead of me. You're 2 steps ahead of me. Let me a second, and I'll get back to that.
You can have a civil issue. Civilly, you can, that can be against the law, but I don't see how criminally, I don't see how it can become criminalized.
Is this an audience of lawyers? Are you doing this as a joke? This is great. Y'all are fabulous. Y'all get it. Y'all absolutely get it. Okay, so for what it's worth, my vote is no. You cannot truly criminalize adultery. In biblical times, marriage was a union established by God. Today, we don't really have the morals police, so no one's going to go to prison for adultery. But as you also wisely recognized, just because we don't have criminal laws does not mean we cannot have civil laws. And North Carolina is one of the few states that has the civil cause of action, known as a tort, if you're a lawyer, of alienation of affection. So you guys all get gold stars for that. Most of you know what alienation of affections is. It means that if John is married to Sue and Jim has an affair with Sue and steals Sue away. I'm just using an example. I'm making up names, so don't come after me for that. Then John, in my example, could sue Jim if Jim steals Sue's heart away under a theory of alienation of affections. Cannot put Jim in prison, but can recover money from Jim. And this is not just of academic interest. It is not at all unusual for an alienation of affections lawsuit to be filed in North Carolina. When I was on the Court of Appeals, we had several, and sometimes the verdicts are pretty darn big. Sometimes punitive damages are awarded by juries. North Carolinians take their marriages very seriously. North Carolina is in a minority of states that recognize this cause of action. There's, as you might expect, there's been a huge debate among legal commentators on whether these are archaic relics, these types of laws that treat spouses, usually women, as subjugated property. And then there are other people who believe that, darn it, marriage is really important, and these are good laws. And for what it's worth, I don't think the legislatures in states like North Carolina would really ever, I hate to say have the guts, but you know what I mean. It would be you'd be sticking your neck out if you introduced a bill to abolish it, and there would probably be a lot of backlash. And that's why laws like this stay on the books sometimes. There are 6 other states that recognize alienation of affections besides North Carolina. First time I gave this talk, somebody asked what they are, so I looked it up. As of the time I looked it up, it was Hawaii, Illinois, Mississippi, New Mexico, South Dakota, and Utah. So an interesting mix of so-called red states and blue states. In addition to alienation of affections, North Carolina also recognizes a companion civil cause of action called criminal conversation. Despite the name, criminal is a misnomer. It's really not criminal, it's civil, but it's called, for whatever reason, criminal conversation. And that means, going back to my example, if John is married to, Sue or Susan, and Susan has an affair with Jim, John can sue Jim under criminal conversation, even if Jim does not steal Susan's heart away, even if she still remains married to John. And yes, criminal conversation suits do come up. And actually, I believe I'm not mistaken when I say that North Carolina is one of several states that actually still has statutes on the book that make adultery a crime that were written a long time ago, but they're not enforced because everybody knows that a court would throw out immediately any type of prosecution under that law as being unconstitutional. All right, let's go to the 8th commandment, thou shalt not steal. What do you think? Would that fly today? Of course. As all of us know, another fundamental tenet of civilized society is the need to protect property ownership. We want stability in the ownership of property. So whether you call it fancy words like larceny, embezzlement, false pretenses, stealing is as illegal today as it was in biblical times. All right, let's go to the 9th commandment. Thou shalt not bear false witness against thy neighbor. What do you think? Would that fly today as a criminal law? I see a nod, yes. See another nod, yes. See some people thinking. Well, in biblical times, this was an offense because the truth was considered to be consistent with the morality mandated by God. Today, lying is generally not illegal, but there are a couple of big exceptions. Those of you who are nodding your head, tell me what you're thinking.
Libel.
Okay, we're going to libel in a second. Libel is civil, not criminal.
Perjury?
Perjury, very
Perjury?
good. Perjury, very good. Perjury. Let's talk about perjury for a second. Perjury, of course, is a special type of lying. When you give knowingly false testimony in a legal proceeding. Why is that a crime? Because the entire functioning of our court system hinges on witnesses telling the truth. And if there's no longer a strong incentive, like a felony prosecution, to induce them to tell the truth, frankly, a lot of people wouldn't. And our criminal justice system would fall apart. And that's why perjury has to be an offense. Now, interesting note, what do we think of, not only from TV, but from real life, about how witnesses swear to tell the truth? What do they put their hands on? Bible, right? What in the world is a Bible doing in a courtroom in this non-theocracy in a land governed by the First Amendment? My goodness, how in the world is that constitutional? You know, it's a darn good question. I'm not sure the U.S. Supreme Court has ever really weighed in on that. But the fact that every courtroom in America, every courthouse in America, has a Bible in every courtroom shows you that there is a continued reverence for the sanctity of God's name in legal actions. And it's considered a really big deal for people to put their hands on the Bible and swear to tell the truth. Some of you are thinking, but of course, you don't have to put your hand on the Bible. You can affirm, and that's true. Witnesses are given the option. It would violate the First Amendment to require witnesses to put their hand on the Bible that they don't believe in. And that's why they have the option of just affirming to tell the truth. If they affirm, they still testify under penalty of perjury. Last time I gave this talk, someone asked me about whether the Bibles in the courthouses are our Bibles or the Christian Bibles. I don't know what it's like in other states, but I have to admit in North Carolina, they are the Christian Bible. On the day of my investiture back in March of 2019, I'm a note writer. I write notes to myself constantly. I must have written 19 separate notes to myself. Bring the Tanakh, bring the Tanakh, bring the Tanakh. And I did, and that's what I put my hand on when I took my oath as a justice.
Yeah, right.
But, okay, some of you had questions. Go ahead.
Right.
Or comments.
Oh, aren't
Michael.
Muslim people allowed to swear on the Quran?
That is a great question. I think what you're getting to is, are people of different religions allowed to bring their own holy book, if you will, into the courtroom? I need to look that up because that is a wonderful question. I've never seen or heard of anyone doing it, but that doesn't mean it hasn't been done. That's an excellent question. But the bottom line is, as long as the witness recognizes that they're testifying under penalty of perjury, whether they're just putting their hand in the air or whether they're putting their hand on a book, I mean, the law is really satisfied. All we want to do is make sure that people understand they've got to tell the truth or they can be criminally prosecuted. So that's perjury. What's another big example of a type of lying that can be a criminal act? Call it out. Unmute yourself. Anyone? How about fraud? How about criminal fraud? Fraud is a broad legal concept that it can encompass a lot of different types of conduct. But, one of the most common types of fraud is when someone lies in order to criminally obtain the property of someone else. That's a form of lying. And that is a criminal offense just as much as perjury is. Okay, somebody mentioned libel a few minutes ago, and that's a great observation. Libel, defamation, not criminal offenses, but kind of like when we talked about adultery, libel is a civil offense, meaning if somebody lies about you in a way that tangibly harms your personal or professional reputation, you can sue them. You can potentially recover lots and lots of money. So that's another example that derives back to the biblical concern with truth. All right, 10th commandment, the last one, thou shalt not covet. If you want, I can pause 5 seconds for you to insert your own joke here as well. What do you think? Could that fly today? No, why not? We don't have a thought police in America, do we? You are free to think the most, whatever you want to think, you can think, and there ain't a cop in the world who can arrest you for it, or a DA who can prosecute you for it. So we're talking about thought versus action. In modern times, thought has to translate into action in order to form the basis for a criminal offense. It wasn't that way in biblical times, of course. Blasphemous thought, illegal. So what have we learned? Well, in biblical times, immorality itself can be a crime. In modern times, immorality is not enough. Typically, there must be an act and there must be a victim in order for a criminal act that can be prosecuted to occur. But there are always exceptions, right? I said a minute ago, there must be a victim. What about so-called victimless crimes like possession of drugs or prostitution or gambling? Not to get in a moral debate, but there are those who believe that those truly are victimless crimes. So why are they allowed to be prosecuted? Well, the answer is, and not everybody thinks about it like lawyers and judges do, but legislatures can make anything they want illegal as long as what they're making illegal does not violate a provision of the Constitution. And there is no constitutional right to gamble. There is no constitutional right to engage in prostitution. There is no constitutional right to take drugs. And that's why legislatures are authorized to ban those acts if they see fit. So, to me, the ultimate conclusion from all of this is, despite the separation of church and state that we hold dear in America and North Carolina today, there really is a strong influence of the Bible on our modern court system and our modern laws. So, that ends my prepared remarks. Let's have a dialogue. Please, Julia, help us out here. Questions, comments?
Yes, does anyone have any questions or comments? You can also write them in the chat if you don't want to share your screen.
This really is the most fun part of the presentation, even though I frequently get stumped by smart audiences like you all who ask me really hard questions.
Yeah, Michael?
Well, what about when the rights of one party interferes with the rights of another, and there's an intersection of that? That is usually a problem. One of the things, of course, that seems to come up, I think about, is abortion. For some people, with some religious views, abortion is not only legal, but is the correct thing to do under certain circumstances, and others it is not, and therefore the issue is, it always seems to be coming up in terms of the legal allowing of or not allowing of that. And it seems to be a situation that actually seems to be going one way or another, depending on some person, people who are involved in the courts having a certain religious background or others. And there doesn't seem to be any quite clear way to handle that.
So I appreciate the comment. He's asking about abortion, so let's put aside the strong moral views that, all of us have moral views about abortion, and, we're all entitled to our moral views, but let's talk about it legally. So remember what I said a few minutes ago. Legislatures can make any conduct they want criminal as long as it doesn't violate the constitutional right. Legislatures have enormous power. That's why there's so many criminal laws on the book. They can make anything illegal as long as there's a rational basis for doing so, as long as it doesn't violate a constitutional right. And, you know, up until 1973, every state had a law that dealt with abortion. Some criminalized it completely. Some allowed it pretty much very liberally. Others were in the middle and placed various restrictions on it. Because up until 1973, the US Supreme Court had never suggested that the right to an abortion might in any way be covered under the Constitution. And then Roe v. Wade happened. And for the first time, you had the highest court on our land, the court that's charged with interpreting the US Constitution and the Bill of Rights. The US Supreme Court shocked the country by saying abortion is no longer on the table for legislatures. Abortion is a constitutional right, you know, with certain limitations about final trimester, et cetera, et cetera. And so then for the first time, that took it off the table legislatively. Legislatures were no longer free to enact laws criminalizing abortion. Now, whether you're so-called pro-choice, whether you're so-called pro-life, again, I'm not debating this morally with you. I'm just saying legally, that's the framework we look at it. Now, was the US Supreme Court right legally? Again, people have very strong views on both sides of that, and everyone's entitled to their view legally as well as morally. But we live in a country where we do have a hierarchy of courts. The Supreme Court gets the final word on what the Constitution means, and that's what they've said. And even though, as you know, we've had a number of refinements, if you will, of Roe v. Wade in subsequent decisions by the US Supreme Court over the last, 47 years? 47 years? My math isn't very good. The US Supreme Court has still adhered to the basic tenet of Roe versus Wade that in some form or fashion, the right for a woman to control her body for reproductive purposes is still a constitutional right. So that's a long-winded answer to, I think, the question you were trying to raise.
Lynn, did you have a question?
Yeah. So I have a question about this new move with the more conservative court toward this whole idea of individual religious freedom and some of those decisions where, like the Hobby Lobby, or I don't remember if the Supreme Court said that an individual, like if you're a nurse and you don't believe in a certain, like if you don't want to, I don't know, if you don't want to do a certain treatment, that you have the religious freedom. Somebody comes into a public hospital and you can say, well, I'm not going to do that treatment. I'm concerned about that. I don't understand how that's even shifting away from, like if you have a bakery and you don't want to serve the public because they're gay or something, that just doesn't seem right that you are allowed to do that. And I don't understand that shifted that. And to me, it's a politicization of that whole constitutional thing.
Yeah, that's a great question. Really, really good question. So if you look at the world like many do, everything's liberal or everything's conservative, which I hate. I hate it when people talk in those terms, but I'm going to break my own rule for a second and assume that that's a valid way to look at things. Up until the cases you're talking about, the religious liberty cases, 99.9% of the time, the constitutional right being asserted in the face of governmental regulation was, again, I hate to do it, but I'll say a liberal right, a right that sort of tied in with political dogma of the people who identified as liberals or progressives. This new trend is very interesting, whether you agree with it or disagree with it. It's just interesting, as a judge, to me at least, because now you're seeing so-called conservative rights under the Constitution be raised to try to bar regulation by Congress or the states. So again, I'm not taking a position either way. The U.S. Supreme Court has ruled a little bit on this. They interestingly, they punted on you may recall, on the bakery case you mentioned, where the baker didn't want to bake a cake for a same-sex wedding. The Supreme Court, that was really closely watched. Everybody was just fascinated to see how they were going to rule and how they were going to write the opinion explaining their ruling. And they ducked the issue, and as you may recall, they decided it on a very much an ancillary ground. But that issue's not going anywhere. There are a number of so-called conservative public interest groups out there who are every day trying to think of new similar types of challenges to bring in courts, in this state courts and federal courts, on this principle of religious liberty. And it's going to be very, very interesting to see how far the courts go in recognizing those types of claims. So more to come on that. Did you have a follow-up?
You can
I think you're still on
What
mute.
is the, sorry, what is the constitutional basis for any of those earlier decisions and now this religious freedom? I mean, what part of the Constitution are they using?
Well, that's a good question. In this particular case, they're relying on the Establishment Clause in the Free Exercise Clause of the First Amendment, like we were talking about a few minutes ago. They're saying, you know, hey, we have strongly held religious beliefs. Selling contraceptives, whatever it is, violates our religious beliefs. So why should we be forced to condone and encourage others to engage in conduct that violates our religious beliefs? Now, you may disagree with them completely. I'm just answering your question and saying that's the basis they're asserting. And it's a very, very fascinating issue. And thank you for raising that point. Anyone else?
Read a question from the chat box. Sean and Harlan asked, is there a relationship between coveting and conspiring?
Oh, coveting and conspiring. Good. So conspiracy is a crime where two people reach an agreement to commit a criminal act. And interestingly, as the lawyers on the chat know, you don't have to actually take an overt act in furtherance of the crime in order to be guilty of conspiracy. As long as two people have an express meeting of the minds to commit a crime, you are guilty of conspiracy. But think about what I just said. There has to be an overt express meeting of the minds. If you're just thinking about it and not translating that into some type of affirmative communication with another person who agrees with you to commit the crime, that's not conspiracy. So again, no thought police. You can think whatever you want. You can think the most, I don't mean you personally, of course. Someone in America can think the most vile, despicable things they want to, and they have not committed a crime unless and until they either engage in a criminal act themselves or enter into an express agreement with someone else to commit the crime. Very good question. Who's that, Rachel?
Yeah, Rachel. You're still muted, Jake.
What is the, particularly as you talk about these varying views, and as polarized as we are as a society today, where are we in terms of either parties or not parties on judicial elections? And because I think at some levels we do identify parties, at some levels maybe we don't. And where are we going? Do you see us getting back to nonpartisan judicial elections, or are we, I hate to say, stuck with putting parties on our judicial elections with all the polarization that entails?
So that's another great question, and I'll give you a little bit of recent history. So the premise of this answer is, let me just say at the beginning, every state does it differently. There's no federally or constitutionally mandated way for states to pick judges. Every state can do it any way they want to. Some do it by appointing judges, some do it by electing judges, some do it something in between. North Carolina has always been a state that requires judges to be elected and reelected. And until 2002, for 200 some years, 225 years, whatever it is, judges always ran partisan judicial elections in North Carolina with R's and D's or I's by your name on the ballot. Then in 2002, the General Assembly said, wait a second, let's experiment here. We're still going to make judges run for re-election and election because the Constitution of North Carolina says they have to, but let's take the R's and the D's and the I's away from their name on the ballot. So let's make the elections and the campaigns nonpartisan. And that's the way it was in North Carolina between 2002 and 2013. Judges still had to run for election and re-election, but there was no partisan symbol or letter by their name. And the state parties did not, they didn't run on the party platform or as a candidate of that particular party. Then in 2013, General Assembly changed its mind and said, okay, we've done this nonpartisan thing for 11 years. Let's go back to partisan. So they went back to partisan, and that's the way it is now. Now judges do run with a letter identifying with their registered political party by their name. And for what it's worth, they don't ask us what we think is a good idea. They just set the rules, and we have to live by it. Personally, I don't know many judges who like having to run with an initial by their name. I know I don't, because judges are supposed to be nonpartisan. We're supposed to be totally independent and above all the partisan warfare that's going on both in our state and our nation right now. And the problem is when the average voter sees an R or a D or an I by a judicial candidate's name on the ballot, they think that, gee, this person is a Republican, this person's a Democrat, this person's an independent, whatever the case may be, this person must, march in lockstep with the platform of that party. And that's so wrong. What we do as judges, we take an oath to follow the law impartially without any sort of partisan agenda. And we take that oath very seriously. And it disturbs me, and I think it disturbs most judges, that there are so many voters out there who really think the opposite, that because there's an R or a D by our name, whatever it is, that we're going to rule in accordance with the policy platform of that party, which is simply not true. But again, they don't ask us to make the system. The legislature, does it any way they want to. So if this sounds like a rant, it's because it is. In our little bubble, we spend a lot of time talking about this issue, and some states don't do it at all. But I will say, even though there are obvious flaws with partisan judicial elections, you look at some of the alternative ways to select judges, and you see there are problems there too. I bet some of y'all were glued to the TV 2 years ago for the Kavanaugh hearings, right? That's pretty must-watch TV. Well, I don't care what political stripe you are. I don't care what party you are. I don't care whether you're liberal, conservative, in the middle. I don't think anybody walked away from that saying, darn it, that's the way we ought to be picking judges. That worked perfectly. No one in their right mind would have said that. That was a train wreck on all counts. I'm not talking about the outcome. I'm just talking about the process itself. It was just awful in every way imaginable. Everybody looked terrible. So my point is, there is no perfect way to do it. There's one of the Western states, I think it's the state of Washington, they have sort of what a lot of judges in North Carolina and elsewhere think of as the Holy Grail. They have a merit selection process in which judges are appointed, and once appointed, judges serve, I think, 14 years, and then there's an up or down a retention election where you have to really be doing a bad job to be voted out of office. So it's like the dream for judges to have that type of system. But to my knowledge, Washington is the only one that has it. I'm sorry to give such a long answer to your question. Some of us in our bubble are obsessed by this topic. So whenever someone asks me about it, it's hard for me to stop talking about it, but I'm going to make myself stop talking about it. Other questions, comments?
I had a question. So we talked a little bit about like the civil liberties and also about like having judges align with parties. But I was wondering if there's ever times when you're in court or doing judge work that you feel like you're making a ruling that aligns with the law but doesn't align with your Jewish values or like your internal moral compass. I was wondering like if you've ever felt that.
That's a great question. One of the things you realize quickly when you become a judge, and you really should realize it before you become a judge, is that when you take that oath to follow the law, it means you have to follow the laws as they are written on the page. You may totally disagree. You may think it's the stupidest law, the most unfair law there is, but as long as it's constitutional, and most things are constitutional, you have to apply it. Sometimes you have to hold your nose and apply it, but you have to apply it. We don't want judges running around saying, I don't like that law, I'm going to ignore it, I'm not going to enforce it. We'd have, a form of anarchy. That's just not the way it works in America. So, there have been a number of times when I've had to interpret a law that I didn't particularly think was wise. And if I had been in the legislature when it was being debated, I probably would have voted against it. But it is what it is. And, I had to enforce it. And particularly when I was on the Court of Appeals, the rule in North Carolina, as it is for most states, is if you're an intermediate appellate court, like the Court of Appeals is, remember we talked about the trial court, then the Court of Appeals, and then the Supreme Court. When you're in the intermediate court, the Court of Appeals, you have to follow every published decision ever rendered by your court. So your court may have made a ruling 5 years ago or 1 year ago or 20 years ago that you think is just idiotic and makes no sense at all. But if a similar fact pattern comes up, you've got to follow that. One of the nice things about being on the Supreme Court is we don't have that rule. We're not bound at all by anything the Court of Appeals does. And we can, we don't do it all the time, but we can overrule our own precedent if we think it was wrongly decided, or if we think things have changed to the point where the original precedent no longer makes sense. So the scenario you're talking about doesn't come up as much now in the Supreme Court, but it does come up quite a bit on lower courts. So very good question.
But it's interesting what you just said. Is there a reason that the appellate court can't change precedent, and that I'll say right to change precedent is reserved for only the Supreme Court?
Well, some of it is sort of inside baseball or maybe in the weeds. The Court of Appeals in North Carolina consists of 15 judges, and they decide cases in panels of 3. And if you had different panels going different ways on different legal issues, it would really be a form of legal chaos because, again, we want there to be stability and certainty in the law. If you're a person and you want to engage in conduct and you're not sure whether it's criminal, you want to be able to rely on what that court has said on that issue. If you're a business and you want to engage in a certain business practice, you want to know whether it's permissible or whether you're going to get sued by your competitor for it. And you want, once one panel of the Court of Appeals to issue, you want to understand that's the settled law in North Carolina. You don't want to have to worry about another panel of the Court of Appeals the next week, ruling a different way on that same issue. You really would have chaos. So that's why the rule exists that the Court of Appeals has to follow its own precedent. But we also want a Supreme Court to be able to step in and say, okay, Court of Appeals, we've looked at how you're doing this. We disagree with you. We think you're applying this rule of law incorrectly, and we want you to start applying it that way instead of this way. So structurally, big picture, it works. The way we do that is something I really agree with. I think you have to have the Court of Appeals following its own precedent, but you have to be able to let the Supreme Court step in when you think the Court of Appeals is driving the car into the ditch, as it were.
Well, thank you. Yeah, I did not understand that difference.
Yeah, it's a great question. Very good question.
Thank you.
These are all great questions. Y'all are amazing.
Are there any final questions before we wrap up?
All right, well, thank you all. Most of you know me or Marcia, and I'm easy to find. And I love talking about all this crazy, arcane legal stuff. So feel free, call me, email me, text me anytime you want. One day we'll be able to be around each other, and hopefully you'll see me in public and I'll see you in public, and we can talk in person instead of over a screen. But I really have enjoyed tonight. Thank you so much for letting me give this talk. I really do love it. Thank you.
Thank you.
So much.
Thank you.
Wonderful.
Thank you.
And I got to take a picture. Such a great audience. All right. Everybody smile. All right. Very nice. Thank you.
Great. Thank you so much for coming. Good night, everybody.
Good night.
And thank you, Julia, for everything you did.
Thank you.
Bye, everybody. Take care.